So very briefly, I will give you some points on privity of contract. So the doctrine of privity of contract, the common law doctrine of privity of contract, is organized according to rules. First of all, a third party cannot be subjected to a contract to which he or she is not a party. So a third party cannot be subjected to a contract to which he or she is not a party. A third party cannot suffer the consequences of a contract that has been passed between two other persons. And second rule, a person who is not a party to a contract cannot claim the benefit of it. So the two principles that you must rely on regarding the notion of privity of contract are the following. A third party cannot be subjected to a contract to which he or she is not a party, and a person or a third party cannot claim the benefit of a contract. Nevertheless, common law recognizes the existence of enforceable third parties' right. So there are some exceptions to this principle, according to which third party cannot either benefit or suffer the consequences of a contract. There are some exceptions. A statute, first of all, the Contract Third Parties Act 1999. So there are exceptions. You want the slide back? Better? You have it on Moodle anyway. No worry. The principle is that a third party cannot either benefit or suffer from the consequences of a contract that he or she has not entered, that he or she is not a party to. But, as always, there are some exceptions to this principle. I give you this information about the existence of a particular statute, the Contract Third Parties Act, the Contract Third Parties Right Act 1999, that organizes more specifically this possibility for a contract to produce limited effect regarding third parties, but it comes out from the practice that all commercial agreements are expressly excluding the application of this act. So this Contract Third Parties Right Act 1999 is expressly the application of this particular act is rejected in all commercial agreement. There are some particular clauses in commercial agreement that expressly settle that this act will not rule this contract. So it comes from practice, from the legal practitioner, that this particular act is falling outside the scope of commercial agreement. They are expressly excluding it. Another theory can be presented very briefly, the theory of collateral contract. This theory can limit the principle I have just mentioned, according to which a contract cannot produce any benefit or any detrimental consequence regarding a third party. The theory of collateral contract can be used, indeed, where two contracts are connected together. Therefore, the main contract can be supplemented by a side contract, and if the side contract is supporting the first one with a warranty or any guarantee or insurance, Therefore, the side contract, the existence of a side contract can be claimed by the parties to the main one. So the effects of a side contract can be claimed by the party to the main contract. Usually these side contract are insurance contract or warranty contract that comes to supplement an initial one that has been passed by two parties, and therefore the parties of this initial contract can claim the benefit of this insurance or warranty contract that is construed as a side contract of the main one. So this theory of collateral contract, where one contract is supplemented another one, can come to limit the principle of privity that forbid a third party to claim the benefit of a contract to which he or she is not a party. Another exception is the contract of agency. Do you have any idea of what an agency is already? No? So I'll give you the definition. The contract of agency is a contract where an agent, a person that is called an agent, is authorized by another, that is called the principal, to negotiate and to enter into legal relationship with a third party on the behalf of the principal. So the agent is authorized by the principal to negotiate and enter into legal relationship with a third party on behalf of the principal. Is it clear? Does it remind you something? When one person is authorized to act in the name and on behalf of one another. Yes? Exactly, the mandat. The agency is similar to the contrat de mandat, the civil contrat de mandat. The principle at stakes are the same. One person will act on behalf and in the name of one another. The legal vocabulary is the main point here to remind for you. So the name of the parties, the agent, the one that is authorized to act by the principal. The agent is mandataire, clause, and the principal is the mandant. Do you have any other idea of an exception to this privity principle? One of the famous agreement that can be passed in common law and that civil lawyers have been willing to integrate until recently, and as far as I know, there's some connection made now with this particular one. Comment? No class action. It's not the one I'm expecting. Where one contract will benefit directly a third party. And it is meant to, since the beginning, that this contract is passed not for the benefit of the parties, but for the benefit of a third one. Yes? No. I will give you the word. It's the trust. Have you heard about it already? No? Never? The common law trust? Trust is not strictly speaking contract, but I thought it was a very famous illustration. Usually it's a famous illustration of what common law can produce as specific, because there is, until recently, there was no equivalent to the trust. Trust is a particular organization of property where one person, that is called the settlor, entrusts some of his property to someone else, that is the trustee. So the property conveyed from the settlor to the trustee. At common law, the trustee becomes the owner of the land or of the goods. However, this contract is passed for the exclusive benefit of a third party that is called the beneficiary. So the beneficiary in the trust contract is the only person that will take advantage from the contract. I won't go into detail here, but of course there could be some reward for the trustee, but the beneficiary of the contract is exclusively the beneficiary. And the particularity of the trust contract is that there are two owners. The trustee is the owner of the good regarding common law principle, because property conveyed to him. But regarding equity, the only owner of the good is the beneficiary. So it's something that we have no equivalent. The French system has introduced recently the notion of fiducie. It's something close to the trust, although not properly speaking equivalent, because the way property is divided in common law is not the way property is divided according to civil Roman law. And there is no equivalent between the two. So fiducie has been introduced in this French legal system, although it cannot be completely compared with the trust. But the trust is another exception to this principle of privity, where one contract, according to which one contract will only benefit or let's say give right to obligation between the parties. The trust is a contract that will benefit directly a third party, and that's why this contract is passed. So the rules organizing privity and the legal effects of the contract are somehow pretty close to what you may already know of l'effet relatif du contrat in the French contract law, but I won't go in details in the exception. You have only this principle to remind, and this exception to be aware that some exceptions exist, although I won't go in detail more. I will spend more time on the fourth part of this chapter, a fourth part that will be dedicated to nullity. Our contract is set aside, and the doctrine of nullity. So we have seen how a contract is passed, the key element that must be made for a contract to be valid. Now we have to wonder where, in which circumstances, a contract can be null. First of all, some legal vocabulary that you must master for the end of this term, and for those who are going abroad next year for studying contract. There are three words that must be distinguished. First of all, the notion of a void contract. A void contract is a contract that is null, that has no binding and no legal effect. A contract has been passed, however, this contract is vitiated. There is no identical theory to vice du consentement. In common law, the theory is the one of, we could translate à vice du contrat. C'est le vice du contrat et non le vice du consentement qui atteint le contrat en droit anglais. So a void contract is a contract that is null, that has no binding, no legal effect. The void contract is null from the beginning. It means that the vitiating element is present since the conclusion of the contract. So the four elements to pass a valid contract are met. However, a vitiating element is present since the beginning. Where the contract is said to be a void one, a void contract, the party's will is irrelevant. Even though the party would like to enforce this contract, that could not be contemplated because this contract is vitiated. Parties have no possibility to confirm the contract or to execute this, to perform this contract. Sorry. This contract is null, it is a void one, it is not null from the beginning, whatever the party intend to do. So it's let's say the situation where the contract is affected by major I can't find the word, major vitiating factor. A contract can also be said to be a voidable one. A voidable contract is a contract that can be annulled by the court, where one of the parties claims for nullity. One or the other party claims for nullity, and therefore, in these circumstances, the contract will be considered as a valid one until its avoidance. This voidable contract is a contract that the court is ready to consider as valid, except where one of the parties claims for nullity of this agreement. And with this respect, the parties' will is a key issue. Whether the parties intend to perform this contract can be performed, and the judges won't have a look at it and won't consider any vitiating element. But where the parties considers that a vitiating factor is present, they can claim for nullity, and after having scrutinized the elements that are presented to the judge, they will decide whether or not this contract is null. So the will of the party is a key issue here, because parties elect to claim or not for nullity. But where nullity is not claimed, this contract will be considered as a valid one. The third word to master is the notion of third notion to master is the one of an enforceable contract. An enforceable contract is a contract that the court will not enforce whether it is required to do so. That means that the court will not put pressure on the party to perform their contractual obligation. Enforcement of the contract means that the court is claimed to push the party to meet their contractual obligation, to perform their contractual obligation. A contract that is not enforceable is a contract that can be regarded as a binding contract, a valid one, if one's look at the core element of the contract, but sometimes one formal requirement has not been met, or one element is missing to make it an enforceable agreement. So parties are free to perform their contractual obligation in this situation. The contract is unenforceable, but if they choose to perform it, the contract is still a valid one. But if one of the parties fails to perform his or her obligation, the other one has no claim for enforcement, because this contract something is missing in this particular contract to make it really enforceable. That could be, for example, a purchase of land that is not made in a written way, whereas it is compulsory when one person is buying some lands or real estate to make it in a written manner. So indeed, I have mentioned it, a contract can be made in written or orally. It does not affect the validity of the agreement. But sometimes statutes may regulate the form of the contract and may state that this particular contract must be made in this particular form of requirement. And if those requirements are not met, then this is a ground for an enforceability. The contract is valid regarding its major elements, but formal requirements are not met. That makes this contract an unenforceable one because these formal requirements are missing. We can give also the example of a contract that has been passed by an underage person in common law. This contract is unenforceable, although sometimes this contract can be performed by the underage person directly. So are these three notions clear for you? It can't be compared strictly to nullité absolue, nullité relative, because the elements are not the same. But if you look at the, let's say, the strength of the concept, it is true that there is a hierarchy. The contract that is, let's say, vitiated in the most important way is the void contract, such as the nullité absolue in the French legal system. Although the conditions for nullité absolue are not the same that the voidability, for a void contract. The voidable contract is a contract that will be annulled only if one of the parties claims for nullity. So is everything clear with these three concepts? Void contract, voidable contract, and enforceable contract. Do you have any questions? Oui?
When it comes to a voidable contract, can it be voided at any time? If they agree to go with the contract, to apply it, can one void it afterwards?
No, I will have to check that because I haven't in my mind right now. I will check that because I can't tell you. But there may be some time limit. But I will check that. I will tell you. I will focus on the first point, on the reason for setting aside the contract. What are the grounds for setting aside a contract? And I will give you a quick overview of each of them. So first ground, that's the one of duress. Duress is a common law theory as opposed to equity and equitable theory. So duress is a creation of common law court, of royal courts. And indeed, a contract entered into under duress is voidable. A contract entered into under duress is voidable. That means that it can be annulled where one of the parties claims for nullity. A contract entered into under duress is voidable. It can be annulled where one of the parties claims for nullity. The key concept of this theory is the one of coercion. Coercion of will. Coercion, it's C-O-E-R-C-I-O-N. C-O-E-R-C-I-O-N. Coercion of will is the key element of duress. Coercion can be coercion can come from direct violence or threats to one person or to members of his or her family. So coercion can come from direct violence or threats to the person or to members of his or her family. Violence or threats can also be orientated against goods, property, or commercial interest. So threats or violence can also be orientated towards property, commercial interest, or any goods or belonging of that person. The consent of the person who has suffered the arrest is not extinguished. Consent is still present. So if you look at the offer and acceptance process, consent is present. Consent has been given. However, this consent is vitiated. It's not a valid consent that has been given to this particular agreement. So the coercion of will, the coercion of consent is a key element. The consent of that person is present, is existing, however, this consent is vitiated. Common law distinguishes three types of duress. So there are three types of duress at common law. Duress to the person, that consists in actual violence or threats directly orientated to the victim, to the other party, or to members of his family. So direct violence or threats directed to the person. I will kill you, I will kill somebody you know, I will hurt you, this kind of threat. Threats must have had an influence on the victim. The threats must have been of that kind that could really change the mind of a reasonable person. It is important here to have in mind that the threats must not be of pure fantasy. It must have influenced the consent. It must have pushed the person to accept this particular set of terms. So threats must have had an influence on the victims to enter into the contract. The second category is duress to goods. However, there are still some discussions about amongst academics about the existence of this ground, but the classical doctrine presents this notion of duress to goods. It consists in threats of damage without S, threats of damage to the victim's goods or property. So the threats or the damage are not orientated to the person or to the closest friends or family of that person, but to his or her goods or property. I will destroy your car, burn your house, or whatever. The threat is orientated to goods. The Skit and Bill case was about the threats of having expensive painting of the owner slashed down by that person. If you don't agree that, I will slash your very expensive master painting. And therefore, the court considered in a bitter dictum that it could amount to duress to goods. The last aspect of this concept of duress is the one that gave rise to the most important debates amongst academics, is the notion of economic duress. Indeed, economic duress arises where one of the parties uses his superior economic power. Economic duress arises where one of the parties uses its superior economic power to coerce the other's will to make that person agree to a particular set of terms that is detrimental to him or her. where one person uses its superior economic power to put pressure on the other to agree to a particular set of terms that is detrimental to him or her. And the question arose so as to know where that party has made an illegitimate use of its economic power. Indeed, the courts had to consider whether economic pressure could be used in commercial agreement or non-commercial agreement, and where this economic pressure could be considered as illegitimate. Indeed, people who are running business know exactly that economic pressure is something that is used in negotiation. That's part of the way of doing things. In commercial agreement, that's something that is commonly used in the course of negotiation. But where economic pressure has the effect of vitiating the weakest party's consent, or where this consent is given under threats of economic nature, therefore it cannot be considered as a valid pressure tool. That pressure can be, in some particular circumstances, be considered as illegitimate. Illegitimate commercial pressure that must be distinguished from the mere commercial pressure, the usual way of dealing, the usual way of doing things in commercial matters. So what is illegitimate pressure? And one of the elements, some element can be found in the Universe Sentinel case. The facts were the following: the ships of the plaintiff were blocked in the by a seamen trade union. There was a strike, and the trade union prevented the ships from going away. And of course, the owner of the ship were losing money each day because the ship were not allowed to go. And the trade union asked those persons to pay money, and to say that we will let the ship go if you pay money to the trade union and to the union welfare fund, the welfare fund for the workers that were affiliated to this union. And indeed, the companies paid, and they claim back the fact that they were forced to pay because of illegitimate economic pressure. Indeed, they were eagerly waiting for this boat to go away because there were some orders to comply with, and the court considered that indeed the economic pressure here was illegitimate, and the money paid to the trade union and to the trade union welfare fund was obtained under illegitimate pressure. So illegitimate pressure can be present in the course of negotiation between parties that are not in contractual relationship, such as in the Universe Sentinel case, but also in situation where parties are already in a commercial contractual relationship. So this commercial pressure can be used either to negotiate a first contract with between parties who are not already in commercial agreement, but also some cases are focusing on the use of this illegitimate economic pressure where parties are already in business together and where economic pressure is used, illegitimate economic pressure is used to renegotiate an existing contract or to vary the terms of it. There are some discussions as well on the issue of threats of breach of contract. I will develop later on this notion of breach of contract. Breach of contract is the fact of non-performing the contract according to its term. The fact that the contract will not be complied with is a threat of breach of contract, an economic duress, or a kind of duress, either economic or not, and academics are discussing the issue. And it seems that the classical position considers that threats of breach of contract is an unlawful threat, threats of breach of contract, of non-performing the contractual obligation. If you don't do that, I won't do my part of the job, I won't do my part of the deal. The threat of non-performance of the contract, of breach of contract, is construed as an unlawful threat and as a consequence as an illegitimate threat that amounts to duress. So economic duress or not, discussions are present amongst academics, but the classical position is the one that considers that the threat of breach of contract is an illegitimate threat that amounts to duress. But the key element, whatever the form of duress is, the key element is the one of coercion of will. The threats or the violence must have been of such importance that it could have influenced a reasonable contracting party, and the will of that person must have been vitiated by the violence or the threat. So you have to have this stuck in your mind. Whatever the nature of duress is, duress to the person, duress to goods, economic duress, or this particular category of threats of breach of contract, this duress must have vitiated the consent of the party, the coerced party. This common law doctrine of duress, must be distinguished from another one that is often connected to it, but that is born from equity and not from common law court. So this common law doctrine of duress must be distinguished from the doctrine of undue influence. Indeed, those theories are connected in some way, but they must be distinguished. Duress is common law. Undue influence is born from equity. It's an equitable theory that has been developed to supplement the weakness of the duress theory. So, undue influence is a creation of equity. So the sources of these two concepts are different and must be distinguished. Duress is a creation of common law, whereas undue influence has been created by equity. So, it's true that those two theories have connections. Duress is defined as illegitimate pressure, violence, threats, illegitimate pressure. and to make the distinction between what is illegitimate pressure, according to the common law concept, and what is undue influence, according to equitable one, sometimes quite subtle to to draw the line between the two. What is duress, illegitimate pressure, and what is undue influence, sometimes it's not very easy to draw a line between the two. But that's what case law has tried to do. The undue influence is the fact of suffering an influence from one person where violence or threats cannot, properly speaking, be proved. One person may claim that she has not been pushed to that contract. There was no threats, there was no violence, but nonetheless, the consent was not totally free because she has been highly influenced by this other person with whom he or she was contracting with. So, indeed, undue influence was built so as to supplement the weakness of the duress theory, where one person was not able to prove that she has suffered violence or threats, but anyway, that person has accepted detrimental terms because she has been highly influenced by another one. According to the National Westminster case, a contract can be annulled on the ground of undue influence where the party who is claiming for avoidance has suffered a manifest and unfair disadvantage. So the contract can be annulled on the ground of undue influence where one party has suffered a manifest and unfair disadvantage. That person has accepted a particularly detrimental and unfair set of terms. There is no direct pressure, no violence, but she has accepted an unfair disadvantage because she has been highly influenced by the other party. There are two categories that can be highlighted. The one that is called presumed undue influence. The presumed undue influence concerns situation where the weakness of one of the party comes from its particular relationship with the other one. So the presumed undue influence covers contract where parties to that contract are related or connected one way or another together. The presumed undue influence can be found in, for example, contract passed between parent and child, or a doctor and his client, or solicitor, a doctor and his patient, or solicitor client. Any situation where one person has a position of influence over the other. And some authors, some academics, ironically, I think, pointed out that this undue influence could also be presumed where a contract is passed between husband and wives. Husband would be the one who would have influenced the wife, and unduly sometimes, but it's a bit ironic, I guess, just to make students have this in mind. But this kind of situation, indeed, can give rise to a presumption of influence, where the contract is passed between two persons that are related together or connected together in one way or another, so that one of the party has a stronger influence on the other. In French, we would say un ascendant. I don't know the English words for that. The fact that one person will use this position so as to lead the other to accept a particular detrimental set of facts. This presumption also applies where a relation of confidence, what is also called a trust relationship, is born between two persons. One, for example, where one person turns to another one for advices, or consider this person as a reliable person, and a contract is passed between those two. The fact that there is a fiduciary relationship, a trust relationship between them, may lead the court to consider that this contract has been passed in a particular situation of influence. However, this presumption of undue influence is a rebutable presumption. Indeed, it is it's completely possible to prove that the person that has accepted detrimental set of facts or detrimental set of terms has acted totally spontaneously and independently, without being influenced by the other. So this presumption of undue influence is a rebutable presumption, and it is possible to prove that there was no influence at all and that the consent has been totally free in this particular relationship. So this is the first category of undue influence, the presumed undue influence in particular situation where the two parties are connected, the one with the other. The second category of undue influence is called the actual undue influence. The actual undue influence, when there is no particular relationship between the parties, but where it is proved that one of the party has exerted a dominating influence over the other. And therefore, it's possible to prove that that party acted unfairly and improperly so as to influence unduly the other one. So there are people waiting outside, and I think I will need more time to go back on this issue. Maybe we stop here, and I will give you the example of William and Bailey case next week. Merci beaucoup.